Hello, this is Malachi Bishop with the Rehabilitation Counseling Program at the University of Kentucky, and this is Ethics in Rehabilitation Counseling. Today we're going to be talking about confidentiality, privileged communication, and privacy. We are going to be looking at primarily Section B of the Revised Code of Ethics, but we're not going to be looking at every element of that important section. Just want to focus on a couple things today. This idea of confidentiality and its limitations, and we want to talk about the law in the state of Kentucky and the importance of knowing the law with respect to confidentiality in your jurisdiction. So I said we will not go through Section B standard by standard, but as we have seen in our discussion of the issues that rehabilitation counselors frequently run into ethical problems with, this is a section that it is very important to be aware of and to pay attention to, and the first section in particular I'd like to actually look at in detail. The first section, first standard in Section B, 1, respecting client rights, deals with cultural diversity and the idea that we will maintain beliefs, attitudes, knowledge, and skills regarding cultural meanings of confidentiality and privacy, and hold ongoing discussions with clients as to how, when, and with whom information is to be shared. And B, we will respect the privacy rights of our clients and solicit private information from clients only when it is beneficial to the rehabilitation counseling process. Third, we will not share confidential information without consent from our clients or sound legal or ethical justification. And D, critically important at initiation. So when we start the counseling process, before we start the counseling process, and then throughout as necessary, we will inform clients of the limitations of confidentiality, the times at which we cannot assure confidentiality, and we will seek to identify foreseeable situations in which confidentiality must be breached. I do want to look at the specific limitations that are identified in the Code of Ethics, and as I said, I also want to review the law in the state of Kentucky. So in the Code, the exceptions or limitations to confidentiality, there are essentially 3, and then there is a statement about disclosure. I want to take these one at a time. First one concerns danger and legal requirements. The general requirement that rehabilitation counselors will keep information confidential does not apply when disclosure is required to protect clients or identified others from serious and foreseeable harm, or when legal requirements demand that confidential information must be revealed. In these circumstances, we will consult with other professionals when we are in doubt as to the validity of an exception. So, first exception deals with when disclosure is required to protect clients or identified others from serious and foreseeable harm. Also, legal requirements demand that confidential information must be revealed. So in the state of Kentucky, there are a couple of statutes I want you to be aware of for those of you who are practicing in Kentucky. Those of you who are practicing elsewhere, I expect that you will have similar statutes in your own state, but I advise you to review those. Most states will have a statute like this one and the next one we're going to talk about. In Kentucky, we have the Child Protection Act, which provides for the protection of children through the mandatory reporting of known or suspected child abuse. And I wanted to share with you the definition of abuse or neglect. It is a child whose health or welfare is harmed or threatened with harm when his parent, guardian, or other person exercising custodial control or supervision inflicts or allows to be inflicted upon the child physical or emotional injury by other than accidental means, creates or allows to be created a risk of physical or emotional injury to the child by other than accidental means, commits or allows to be committed an act of sexual abuse, exploitation, or prostitution upon the child, creates or allows to be created a risk that an act of sexual abuse, sexual exploitation, or prostitution will be committed upon the child, abandons or exploits the child, does not provide the child with adequate care, supervision, food, clothing, shelter, and education or medical care necessary for the child's well-being. A dependent child means any child other than an abused or neglected child as described above, who is under improper care, custody, control, or guardianship that is not due to an intentional act of the parent, guardian, or person exercising custodial control or supervision of the child, and who shall report in Kentucky. There's mandatory reporting for any person who knows or has reasonable cause to believe that a child is dependent, neglected, or abused. And in Kentucky, we will cause an oral or written report to be made to a local law enforcement agency, or the Kentucky State Police, the Department for Social Services, the Commonwealth's Attorney, or the County Attorney. Unless requested by law enforcement, the Department for Social Service investigates only those cases of abuse or neglect alleged to have been committed by a parent, guardian, or other person in care, custody, or control of the child. So anyone in Kentucky is a mandatory reporter. Let's look at adult protection now. The Adult Protection Act in Kentucky says that any person who becomes aware of any case of an adult who may be experiencing abuse, neglect, or exploitation shall report it to a representative of the Cabinet for Families and Children. And the definition of an adult under the statute means a person 18 years or older who, because of mental or physical dysfunctioning, is unable to manage his or her own resources or carry out the activity of daily living or protect himself from neglect or hazardous or abusive situation without assistance from others, and who may be in need of protective services, or a person without regard to age who is a victim of abuse or neglect inflicted by a spouse. Again, mandatory reporting for any person, including but not limited to physicians, law enforcement officers, nurse, social worker, department personnel, coroner, medical examiner, alternate care facility employee, or caretaker. But any person having reasonable cause to suspect that an adult has suffered abuse, neglect, or exploitation shall report or cause reports to be made in accordance with provisions of this chapter. Death of the adult does not relieve one of the responsibility for reporting the circumstances surrounding the death. And be aware that KRS 209.050.060, anyone acting on reasonable cause in the making of a report in good faith shall have immunity from any civil or criminal liability. Neither the husband nor wife nor the psychiatrist patient privilege shall be ground for refusing to report known or suspected adult abuse. So there is no privilege in the case of reporting known or suspected adult abuse. I also want you to be aware of KRS Section 202A 400, which says the duty of mental health professional is to warn intended victim of patient's threat of violence. This deals with not abuse, but another issue where this clause of the Code of Ethics would come into play. And the statute says no monetary liability and no cause of action shall arise against any mental health professional for failing to predict, warn of, or take precautions to provide protection from a patient's violent behavior, unless the patient has communicated to the mental health professional an actual threat of physical violence against a clearly identified or reasonably identifiable victim, or unless the patient has communicated to the mental health professional an actual threat of some specific violent act. Be aware that rehabilitation counselors may not necessarily fall into the definition of a mental health professional in Kentucky, the exception of licensed professional counselors who are certified rehabilitation counselors. And it is important always, I think, in a case like this, to understand your agency's policies and to consult with supervisors and colleagues, as it's suggested in the code, when you have questions about the validity of an exception. The important thing is that you become well aware what the statutes in your state, what they say, who they cover, and what your responsibilities are in situations where clients are at risk, or where you learn about risk of abuse, neglect, or dependency, or a threat of harm. Let's look at the second one here. Contagious, life-threatening diseases. This is one that gets a lot of attention, and in reality, I haven't seen it actually receive a lot of attention in terms of complaints or questions to the for advisory opinions, but it is one that we need to be aware of. And it says, when clients disclose that they have a disease commonly known to be both communicable and life-threatening, rehabilitation counselors may be justified in disclosing information to identifiable third parties if they are known to be at demonstrable and high risk of contracting the disease. So we may be justified in disclosing information to identifiable third parties if they are known to be at demonstrable high risk of contracting that communicable and life-threatening disease. Prior to making a disclosure, however, rehabilitation counselors confirm that there is such a diagnosis, assess the intent of clients to inform the third parties about their disease, or to engage in any behaviors that may be harmful to identifiable third parties. I want to identify an important point here. In the prior version of the code, the statement was a little different. It said, in jurisdictions where allowable, a rehabilitation counselor who receives information will confirm that a client has a disease known to be communicable and or fatal, and if allowable by law, will disclose this information under certain circumstances. So the more recent version of the code eliminates this discussion of jurisdiction in law. However, it is still required in the current code that we are familiar with and obey the laws and statutes of our legal jurisdiction. Unless there's a conflict with the code, and if ethical responsibilities conflict with the law, regulation, or other governing legal authorities, then we will make known our commitment to the code and take steps to resolve the conflicts. But if conflicts cannot be resolved by such means, we may adhere to the requirements of the law. And I bring this up because in Kentucky, vocational rehabilitation counselors are not included in the categories of professionals who are required or permitted to report or disclose HIV/AIDS status to third parties. So in effect, we would be not acting legally if we were to make such a disclosure. I believe, and I have spoken with many others who feel the same way, that if we are faced with a situation where we're working with a client with a communicable and life-threatening disease, and there is some threat to a third party who is identifiable, the most important primary communication is with our client, and trying to educate and ensure the safety of our client and identifiable third parties. But working with the client is, I believe, the primary route in dealing with a situation like this. Court-ordered disclosure is another exception. When we are subpoenaed to release confidential or privileged information without the permission of clients, rehabilitation counselors will obtain written, informed consent from our clients to take steps to prohibit the disclosure or have it limited as narrowly as possible due to potential harm to clients or the counseling relationship. So in other words, when we are court-ordered, subpoenaed to release confidential information, we will first obtain written informed consent from clients, or take steps to prohibit the disclosure. So we will act to basically let the court know that we may not have privilege. We would because of potential harm to the clients or the counseling relationship, we would ask that the information remains confidential. If not, we would act to obtain written informed consent from our clients. Whenever reasonable, we will obtain a court directive to clarify the nature and extent of the response to a subpoena. So if we are court-ordered, then we have the exception to confidentiality. We may be compelled to disclose confidential information. We try to do that with our clients' consent, and we try to do it in a way where we minimize the extent of the response to a subpoena. And the last section of this last standard in the section deals with minimal disclosure. In any of these circumstances, when circumstances require disclosure of confidential information, only essential information is revealed. So we only provide the essential, the critically important information, but basically we don't provide more than is necessary. Okay, again, I'm not going to cover every element of this standard, but there were a few other issues I wanted to bring your attention to, because this one too has received a lot of questions and complaints from rehabilitation counselors, this idea of work environment. Be aware that the code says that we will make every effort to ensure the privacy and confidentiality of our clients is maintained by employees, supervisees, students, clerical assistants, and volunteers. If we are working, if we are sharing information among team members, if we are working in a professional interdisciplinary team, then the clients need to be advised of this fact and informed of the team's existence and composition. So we need to inform our client that we are working with a team, that we will be sharing information with a team, and who is on the team. We will consider implications for clients in extending confidential information when we are participating in service teams. I already talked about the when we are working with clients who are being served by other professionals or rehabilitation counselors in a previous discussion. important to be aware that if we are working with a client who is using an assistant, including, for example, an interpreter or a personal care assistant, then it is our responsibility as rehabilitation counselors to ensure that the assistant is apprised of the need to maintain and document confidentiality. So it's our responsibility to make sure that the assistant understands the confidentiality and maintains the confidential information. Clients at all times have the right to decide who can be present as an assistant. And finally, rehabilitation counselors discuss confidential information only in offices or settings in which they can reasonably ensure the privacy of their clients. This is another area where a lot of ethical complaints and questions for the advisory opinions have been raised. Is the environment in which you are working with clients confidential, and does it provide privacy? Third-party payers. We disclose information to third-party payers only when clients have authorized such disclosure, unless otherwise required by law. This is if we are serving clients as rehabilitation counselors, and we've seen, and you should be aware that there are different relationships that we may be involved in if we are working with third-party payers. The other issue to be aware of is that rehabilitation counselors protect the confidentiality of deceased clients consistent with the legal requirements and agency policies. Okay, again, I'm selecting one standard here to look at concerning release of confidential information when we are working with minor clients or adult clients who lack the capacity to give voluntary informed consent. And so this is under section B5, and it says that in that situation, where the client cannot provide voluntary consent, we will seek permission from parents or legal guardians to disclose information. We will inform our clients consistent with their level of understanding and take culturally appropriate measures to safeguard the confidentiality of clients. In other words, even if the client is not able to give voluntary legal consent to release information, we still will seek to inform the client and hopefully receive assent for the sharing of confidential information. Another important issue here, dealing with client records. Counselors realize that counseling records are kept for the benefit of clients, and therefore we provide access to records and copies of records when requested, unless prohibited by law. Important issue here is that two things. In situations involving multiple clients, so if we were working in a group counseling situation, for example, access to records is limited to those parts of the record that do not include information related to other clients. So if we are working in a group or a job club or some situation where there are multiple clients and a client wishes access to their records, then we would permit and provide access only to the records related to that specific client. And the other point I wanted to make sure you're aware of here is that when counselors are in possession of records from other sources, then we do not provide that to the client, but we refer clients back to the source of that information. So if we have reports or records that came from another professional, we refer the client back to that professional, that agency, the original source for that information. If personal information has been obtained from another agency or organization, it may be released only by or under the conditions established by the other agency or organization. So important to be aware of that. We've seen that disclosure and informed consent are two of the areas where basically from which a number of, probably the largest number of ethical issues and problems emerge. So I just wanted to remind you again, informing clients and potential clients of their rights, the limits of confidentiality at intake and throughout the counseling process, in writing and orally, is often overlooked, is time-consuming, and often seems extraneous, but it remains important and a fundamental right of the client. But it's also an important source of protection for you as a counselor and for your client from unethical actions and misunderstandings. So as regards informed consent, I'd say it is never too often. It is often too late. And just remember to put yourself in the client's shoes. When we're thinking about confidential information, think how you would like to be treated, and follow the guidelines of the code, and you should be in good shape.